All right. Welcome, everyone. This is Curt Ferrone,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for June 24th of 2024. Brad, go ahead.
Hi. So, boy, this one's weird. Let's start in New York, where we've
I feel
got.
bad for this guy. I feel bad for him.
You do?
Yeah, I really do. I think he made a terrible mistake, and I think he made a mistake for the right reasons because he felt like he was being treated badly. But geez,
Yeah. Well, look, the short facts are right. This guy goes to a call, elevator emergency. He's an EMT. Is well, I guess maybe a fire commissioner, but he's with the Woodmere Fire District. I think that's down in Long Island.
not one of your clients, I take it.
What's that?
Not one of your clients.
I don't think so. No, I would have known about this. And in any event, he responded to a Jewish synagogue, a temple, and reportedly, children were trapped in the elevator. That having to do with nothing because he's accused for some reason of inappropriate conduct or etc. with the kids, and people are threatening criminal charges. So he then, I guess they're dismissed originally, the first set of, let's call them criminal charges, over a jurisdictional issue. They weren't filed within 90 days as required by law, so they're kind of deemed abandoned. But he then takes the transcript from the court and he adds a line stating, quote, notwithstanding this court has believed for some time that the people's case lacked substance and should not have reached this point. And that the court never said that. So he then sends that out to people to plead his innocence and then gets charged with that, now falsifying public documents. And now he's convicted ultimately of doing that. It's an interesting issue. He takes a public document, alters it, and they said he was resubmitting it. That's the part that I'm kind of caught on. He just should have done that.
I think there was a history on this, and it took me a couple of hours of reading different articles and certainly the press release from the prosecutor's office and his civil suit. But there was apparently some animosity that he had going back to him reporting another board member of the fire district, and he accused her of some financial improprieties. She ended up not getting reelected or whatever. She then makes these allegations against him. And apparently, from what he said, the department's medical director looked at what he had done and said it was appropriate, that the examination that he gave was appropriate. So, but the police ignored that. And so bottom line is the charges are dropped, but not on the merits. And I had a client early in my career that I got a case dismissed, and he was mad at me because he and this is a felony. It was one of the most serious ones, that a kidnapping case, but he was upset with me because he wanted to go to trial to vindicate himself. And I know. And I said it'd be malpractice for me to ignore this opportunity to get the charges dismissed. So I got him dismissed on a technicality, but he felt like he hadn't been vindicated. So, and I think that's what this gentleman was hoping for. Certainly you're relieved that the criminal charges went away, but it wasn't on the merits. He felt like he had been wronged. And this is a devastating allegation, by the way. It affected, certainly the fire department, affected his his synagogue and his membership in the church community. So bottom line is
he then commits a crime to vindicate himself.
So and then he gets sentenced, which that is another thing.
Because in New York, no one goes to jail. Even like and I'm not kidding, attempted murderers barely go to jail.
And this guy's going to jail.
Right. Crazy stuff. He shouldn't have done it, but he doesn't deserve this.
You know what I'm saying? And I just, I don't know. It just feels kind of heartless. But again, usually when things don't seem right, there's more to a story that we don't know about. And
I'm sure.
At any rate.
All right, well, let's go to Pennsylvania. And as we're talking about cases I disagree with, I really disagree with this. I hope they appeal it for a couple of reasons. And I had to really go through the decision after reading this. It's very confusing, but I can summarize it fairly easily. So we've got a volunteer firefighter who's very upset with the fire chief on for a lot of reasons. And he goes to the city council and is urging them, publicly speaking, urging them to take action against this chief. And a number of members get terminated, expelled. So the fire company, I believe, according to him, authorizes this individual as treasurer to cut a check for legal fees. The funny thing is, I've had this exact case where I was the lawyer receiving it. And so, but 5 firefighters were kicked out. And so rightly so, I guess the fire company cuts, says, okay, treasurer, you can cut a check. He didn't make the decision. He cuts the check. So now what happens? The fire chief and some others now say, aha, now we can get you because, right, you spoke up against us or for whatever alleged reason. And they go after him for cutting a check illegally without authorization, basically misappropriating funds in the amount of about $21,000. So, I mean, that part's, insane, but the court goes through all the allegations. 2 of them I want to talk about in depth. And my notes are to myself are like, you must be kidding. So the court goes through and dismisses everything for a lot of reasons. Some just basic pleading reasons, saying you didn't plead enough, right? But the court says, we're not even going to allow you to fix this, which most courts will say, okay, we'll allow you to replead, right, before it's finally dismissed. In any event, the court says, like, first on the First Amendment claims, which again is insane to me because this is usually a jury question to determine whether one person's speech, conduct, related to the retaliation against him. That's a jury question. But the court says there's no temporal connection between his alleged citizen speech in 2019 and June 20, right, and his April 21 suspension. Now, 2 years may be a long time, right? 19 to 21, but then you got 2020 and 21. But he said there's no connection. I don't know. It's one thing to say that's a very long time because it is. I raised that defense.
We talked about this, I think, last week, and
yes.
there's a temporal inference when someone exercises, for example, First Amendment speech, or they complain about something to OSHA or to someone, they're a whistleblower. But when there's a temporal connection, that creates the inference. That's not the only way to establish retaliation, though.
Right.
It can arise by inference or implication, but when you have testimony or other evidence that the person acted with retaliatory animus, that is a second way to prove it.
And I think he has it because one of the things he's complaining about is this fire chief, how he treats members, and we're going to lose members, and they lose 5 members, right? And then they cut a check to defend the members. To me, it's all tied together. There was at least enough for a judge to say this should go to a jury, but he doesn't do that. And and this is just a lower court, right? So it could easily be appealed. But the one that I have, you must be kidding on, is the 14th Amendment claim, which is a due process claim where he said I was denied due process. And the judge says membership in a volunteer fire company is not a property interest. Wait a minute, I've got tons of Court of Appeals decisions that say it is, and I've won many cases. I got 2 or 3 pending now, but we keep winning these cases that say membership in a volunteer company is a property interest. So I don't know where, and I didn't look at the Third Circuit case. He cites one. I don't know if the Third Circuit disagrees with most of the other courts, but are you aware of a line of cases that says it's not?
I think they look for different things, particularly low SAP benefits and those types of things to find the property interest. If not, there's a liberty interest as well that can arise as well. But the property interest usually has to be associated with some sort of monetary remuneration. Some courts will find it, and this is where judges have a lot of latitude, I think, at the trial level anyway, where they really feel like somebody's been wrong, they'll find a property interest. And then other times they want to play, nope, and they find no property interest. But bottom line is, I have seen cases where they find it based on a low SAP or some sort of, stipend that the folks receive. I've seen courts dismiss that. So no clear guidance that way.
Yeah, I was really shocked, and they didn't even look into any factors other than he just has no property interest and gone. And it's not that easy for what
Right.
you're saying.
I agree.
In any event, maybe there's something more going on. Maybe the judge just not interested, but I thought he had alleged enough. I really think this should have gone to a jury to determine whether there's some retaliation that took place. And, you know, I don't know. I think he got wronged, but I kind of hope he appeals.
Well, is sort of a connection here where we have, unfortunately, volunteer organizations with people who aren't getting along with each other, and the police get involved. We have allegations of criminal conduct, and it just turns into a
But
mess.
you know, you're just a treasurer and you cut a check and there's a company votes in the minutes. That can't result in liability. That's not your liability.
Unless you know, it's very clear by the bylaws that, or the articles, that this is not an appropriate expense, that the money in the account is strictly for hose and I'm just saying that would be, but the solution there would be the corporation going after the treasurer,
right?
Not, you know,
not criminal charges. It's a civil issue, whether you had the right authority or not. It's not an intentional misappropriation. Everybody knew he did it. It wasn't the normal theft we see.
I think about both of these cases, and the IAFF firefighters sitting back, eating popcorn, watching this, going, "Oh boy."
Yeah.
You know?
True.
But,
True. All right. So let's go to the Ninth Circuit in Spokane.
Yeah, we got to come up with a euphemism here, because we cannot use the C word, because YouTube will ban us. So what do you want to use for a euphemism for the C word here? How about YouTube? So whenever you're going to
YouTube, right? They got YouTube 19.
And for those of you who aren't familiar with what happens, is YouTube has these bots that read literally every word that we say. And if we use that C word, we get subjected to heightened scrutiny. And we're not talking about a female anatomy part either. We're talking about a C word that has to do with illness that we all experienced a few years ago. But if you use that word, then the bots come and look, and we actually got sanctioned for talking about what they said in a case, not what we think, what we said in a case. So we're a little bit on the paranoid side about using that. So we'll use the term YouTube whenever
YouTube it is. It's YouTube 19. Yeah.
YouTube 19. There you go. YouTube 19.
YouTube 19. So this is a great decision. This is, I think, you know, for what it matters, the right decision. And here's what it was. So a number of firefighters in the county claimed a religious exemption to the YouTube 19 vaccine, and didn't want to take it. They were terminated ultimately for not complying with the mandate. But what the court 100% gets right here, it's not a total victory. Basically, they just remanded it. But what they said is, wait a minute, there was evidence that the fire department would bring in firefighters, mutual aid, or for other reasons from other departments who didn't have the YouTube 19 vaccine requirement. And so it's kind of a, put into layman's terms, a BS, argument. And the judge calls BS on them, to use non-legal terms. And you know, it remands the case for reconsideration under this standard. But really, the court's laid out, listen, you know, to the district court, this court has laid out, listen, you've got clearly an irrational application of what would have otherwise been a valid purpose. Many courts have said no religious exemption. But what they haven't done is like here said, okay, well, you can't claim a religious exemption and then be using firefighters into your department who don't have that exemption and say it's meaningful. It's not meaningful.
Well, I think what the Ninth Circuit really got to is the heart of the strict scrutiny standard. And they said that, first of all, in order for a government to impact people's constitutional rights in the way that they did here, or interfere with someone's sort of religious beliefs, that kind of scrutiny is what we call strict scrutiny. The court is going to look at whatever government is burdening people with, and government's going to show that there's going to be a compelling governmental interest, which in this case, I think they've got it. Okay. But then they've got to tailor the requirements to the absolute minimum. that when you burden someone's religious rights, you've got to tailor it to the absolute minimum. And they said that the firefighters plausibly pleaded that they were being treated differently than mutual aid responders and also AMR. They said AMR granted these exemptions. And so again, the Ninth Circuit returned it down to the district court and said, you've got to apply, you said you applied strict scrutiny, but you didn't. You started to, but you didn't, particularly with regard to the city sort of not really exempting mutual aid, but just if it's so bad that you've got to fire people who don't do this, then why are you allowing mutual aid people in who don't meet it? If it's that bad,
right?
If it truly is that bad, then you should have prevented them from coming in as well. And that may be over the top. I don't know what the Supreme Court would say. Maybe the Supreme Court would agree with it. But bottom line is, at least in the Ninth Circuit, you've got to look at what are your mutual aid partners doing. If your mutual aid partners are allowing exemptions and you're not, that it opens up a little window of opportunity here for that for the YouTube vaccine mandates.
And I don't agree with the AMR. You know, that really has nothing to do with the fire department. The fact that AMR comes in for 20,000 or whatever.
Mutual aid doesn't either, right? Mutual aid doesn't. But the fact that it's happening, like and I think this is if I can get in the head of the court and the plaintiffs here, if it's that bad, if it's that dangerous that you have to terminate us, then is it really that dangerous if all these other people don't have to? And I think that's what they're getting at. If it was really that bad, if we think about maybe what if it was smallpox, or what if it was Ebola and there was a vaccine for those things, and you're allowing some people to, but not other people, you would say, no, you can't come in at all unless you've got your smallpox or whatever, you've got your Ebola vaccine. So I think that's kind of what they're getting at.
And I think the biggest line here is this, that, and again, this is just what the complaint alleges, right? Whether true or not, we don't yet know, but the complaint alleges once unvaccinated firefighters were terminated, that Spokane would then turn to firefighters from neighboring fire departments to fill the gaps. That's the point, right?
Yeah, but I don't think that's actually, I can't imagine that they're actually having them come in and staff their trucks, but they are coming in on mutual aid. So if they've got to brown out a station because they don't have enough people, guess who's coming in? And so physically, it's not untrue. Again, it's another example of probably two lawyers arguing a case in front of a judge, none of whom are firefighters, none of whom truly understand what's going on.
Do they mean mutual aid? Do they mean filling shifts?
You mean they let people from out of town come in? And oh, yes, it happens every day. Well, yes, it does, but not in the way that you're probably thinking it happens, but it does. So
anyway, but it's a common sense decision. You can't claim one thing and then allow others to do another thing, and you say it's okay. It's not okay if we do it, granting an exemption, but it's okay if you do it and we'll use your services. So who knows? Who knows?
Yeah,
but
and it'll be interesting to see if other departments and other plaintiffs now that are wrestling with this might go back and amend their complaint to include that kind of a mutual aid kind of allegation.
Yeah. So. And I agree with you. Mutual aid doesn't make sense. We can't control that, right? It's different when you're saying we're filling shifts with people, if that's true.
Right. And I don't think that's, I don't know for sure, but
I can't imagine.
I don't think that's it. I think it's just mutual aid coming in.
I agree. It doesn't make sense that a department would have to reach out to neighboring departments. Now, if they're on part-timer lists, and say, okay, we'll call them in, you different issue.
Right. Per diem and absolutely. Yeah.
Okay, let's go to Houston.
Boy,
why don't you just
watching this one?
Wow. Why do you do this?
This is unbelievable. And I don't even know where to begin other than to recommend that you go back and look at some of the earlier posts on this. But the Houston firefighters, I think at one point they had parity with police. And we saw this in Providence. It's a very similar thing happened where we were pretty much, a firefighter, patrolman, we were like one rank off of them. So their sergeants were like our lieutenants, their lieutenants were like our captains, and right on up. But typically we stayed in lockstep. And I forget what happened. Something happened, and all of a sudden we didn't get a pay raise. They did. We got a little bit of a pay raise. They got a bigger one, and now we're starting to get a gap. So there was a problem there. They tried to resolve it. It wasn't resolved. They actually lobbied the public and were able to get a referendum to mandate parity. And that ended up passing. The city challenged it. It was struck down, I think, by the Texas Supreme Court as being unconstitutional. And all this took time. Then there were several other suits. There were suits about funding pensions. And in the meantime, they had a bunch of really tragic incidents happen as well. And bottom line is, it took 8 years to get this resolved. The local 341 lobbied hard to support the current mayor to get him elected, and they were successful. And the last mayor pretty much hated the firefighters. So this mayor was very supportive, and they're actually to $1.5 billion. I have never mentioned that big an award or settlement. It's just mind-boggling. And that's a huge fire department, by the way. It's very, tremendously large. But bottom line is, they're getting $650 million in back pay. The city doesn't have $650 million available for that, so they're going to fund it. I don't know, through a bond issue or whatever, but they're going to fund it over a 25-year period. And then there's a series of pay increases that they're going to get over the upcoming. I think it's a 3-year collective bargaining agreement. So I think everybody there, other than the taxpayers, but I think everybody there is breathing a sigh of relief that this is, now been resolved. But what an ordeal they went through to get to this point.
Yeah, incredible. Wow. I looked at that until I got to your second line of "this is not a typo." I'm like, there's no way that is right. Okay, well, let's wrap up in Boston. Now, listen, before I say this to the viewers, Curt and I both know the HR division in Boston. We just report on this stuff and comment without, loyalties or beliefs or, any predisposed, well, they're good, they're bad, whatever. But I got to tell you, I'm a little shocked at Boston.
I am shocked.
If this is true.
Right. If the facts are what is alleged here, I find it hard to believe that the city went after this guy.
And this is so, in my opinion, so clearly a First Amendment protected statement. But here's what happened. The facts are pretty simple. The facts generally are that allegedly, right? All allegedly, so I can stop saying this, because it's just a suit, not a finding. But allegedly, there were a number of citizens complaining that there's a sidewalk out in front of a firehouse that's a tripping hazard, it's very dangerous, and there's a lot of alleged complaints being made. An individual and they're being made to the firefighters at the firehouse. And, so the firefighters are rightfully passing it up the chain of command, despite the allegations against them. And nothing gets done, allegedly, although they said, we'll take care of it. But the complaints start, still keep happening. And it's on a public sidewalk. That matters. A public sidewalk in the front of the firehouse, but they're complaining to the firemen in a public building. So an individual, I think he makes one mistake, but he's, union, and he sends a letter, an email saying you need to take care of this. We keep getting complaints. Unfortunately, in the email, he uses these words: as a firefighter who proudly works in the neighborhood and spends time outside the firehouse interacting with constituents, we are constantly asked when this issue is going to be resolved. I hate his line, as a firefighter.
But how can you be a union rep if you're not you can't be an IAFF union rep if you're not a firefighter. So
that will be the argument. But for the viewers, what Curt and I are debating is, the first question, is he speaking as a employee or as a union rep, a non-employee? If he's speaking as an employee, his speech probably is not protected. He's speaking as a non-employee, his speech is going to be protected.
Wait a minute. His free speech right may not be.
Right.
Okay. But the First Amendment goes a little broader, right? There's other things in there: freedom of association, which then ties back to concerted activity, and the right to petition government for redress of their grievances. And so both of those kind of can get in there where maybe there's a different level of analysis that doesn't go to Pickering. You understand?
Right. Yeah. It doesn't go to the First Amendment speech issue, but maybe the assembly issue. A great point.
Yeah.
He's suspended for 4 days from this email. And you know what? Some people would be like 4 days, 30 days, who cares? But he's right in trying to stand up for his rights. And one of the things they say is he sent an intimidating email.
I don't see that. I just
there's
don't see
nothing
that.
intimidating in this. So let's not.
He's saying, look, the city's going to be held liable for this. Why unnecessarily subject the city to liability? It's not threatening.
Right.
You know?
It's to me, it's concern for the residents, their safety, and the city, who clearly would lose a lawsuit having had notice of a substantially dangerous condition for which they did nothing about.
You have a captain at this station that has been repeatedly using the chain of command and trying to get somewhere with it, right? And it's going nowhere over the course of years, including after people have gotten hurt, baby strollers have gotten stuck in the cracks and all that stuff. So there's all sorts of problems there. As a union rep at this station, undoubtedly, the people are coming to him saying, we elected you to be our union rep, do something. And that includes the captain. The captain in Boston, the captains are members of the local. And so even the captain's going to say, hey, look, we pay our union dues. You're supposed to help us with these types of things.
Which will be his argument that he's speaking as a union rep.
And he sent it from his union email address,
All in favor of that side of the argument.
Right.
I personally believe he's hiding behind that so that he can speak not as an employee. And I think it at least deserves a fair inquiry who is he speaking as?
Right. Absolutely. Absolutely. But I think a 4-day suspension without pay versus, hey, next time don't say you're a Boston firefighter, say you're writing on behalf of the local, would be the conversation. But again, there may be more that we're not aware of. And knowing who we know in the Boston Fire Department, I find it hard to believe they would have made a mistake like this if legal counsel, they have some very, very good
smart
attorneys there. And I can't believe the attorneys would have supported this based on what we know. Now, there may be additional factors. It's possible the decision had already been made before legal got involved as well. But I think a simple First Amendment, I would not recommend discipline. If this was my department, based on what I see there, I would not recommend discipline. Certainly sit down with them and maybe sit down with the union president, the E-board, and say, look, you're going to send emails. We get it. We're going to send emails. Just make sure you do it in a way that you're clearly doing it from the union's perspective.
And let me ask a good question, because if I'm the viewers, I'm thinking, and this is a huge issue. Listen, I've complained about something to the chain of command multiple times.
Yep.
Don't I have the right, and my answer is going to be no, don't I have the right to step over the chain of command when I'm not happy with an outcome or the lack of outcome, because I think it's really important? And my answer is you don't. As a firefighter, you don't.
That's right. I agree. Absolutely. But as a citizen, as a taxpayer, as a union rep, you certainly do.
That's what he should have said. And I'll tell you what, there were better ways he could have done it. He could have said, one, I'm an employee, fine, and I walk out of the station and it's a dangerous part of my workplace. So we could have raised danger to the workplace.
And what does that get you? Whistleblower.
There you go, right? So now he couldn't get in trouble reporting it. Two, we could have said, I'm a private citizen who uses this sidewalk and I'm concerned. He could have done that. He doesn't give up his First Amendment rights to complain of a dangerous condition if he uses that sidewalk. And of course he does at other times other than work. Or frankly, I'd just go, I don't know, call up the chief, do something. But just because you're really upset with you're not getting the answers you want, you know what? Then we'd have no chain of command if that was true.
No, absolutely.
But he had better ways to do it. But there's got to be more to this. There's no way that HR legal at Boston,
unless somebody pulled the trigger on the discipline before they consulted legal, maybe they figured it was such an obvious violation that they had to do something, and now legal's like, oh, what do we do? Do we back up the person who decided this, or do we,
Right.
So.
And look, this is a leadership issue as well. That's a little beyond our video series here. But, as a leadership, we may think, I don't owe you an answer, right? I'm the chief or I'm the whatever. I don't owe you. And that's true in discipline. right? A lot of times that's true in discipline. I don't owe you an answer. You have, and I've used the line that I probably learned from others, just because you don't know the outcome doesn't mean there hasn't been an outcome. But that said, when the problem is still persisting, I think you at least owe, hey, I've submitted this up the chain. I've heard you. I agree with you. I've submitted up the chain. It's beyond me. I can't do anything about it. It's a funding, a finance issue. It takes DPW. It takes zoning. Whatever it takes to fix the darn sidewalk, right? Maybe there's a root under the tree. Who knows, right? And you can't cut down the tree. I don't know. But leadership wise, you should at least acknowledge the complaint. It's valid, inspect it, come out and look at it, shake the guy's hand, say, sorry, you have to take the, the brunt for the city. So there is a leadership issue that could have prevented this entire thing.
Yeah, no doubt.
Hey, that's what we got.
All right. Well, yeah, it's a very interesting week and very contentious series of lawsuits. So, but that's going to do it for another edition of Fire Law Roundup. Please don't forget to click like and share if you like what you saw, and tell your friends. And Brad, we'll see you again. Oh, you're on vacay next week. I
am on vacation next week. So you will, however, get a lawsuit I'm about to file, which you could discuss without me, which would be great. Cool. But it's a good FLSA and whistleblower lawsuit. But that hopefully will be filed sometime this week. In any event, I will be on vacation for the week, and hope my substitute is more smart than I am.
Well, we'll try to get a pinch hitter in here, probably Bill Macaron. We'll see what his work schedule is like. We'll see. We'll get a pinch hitter in for you. So we'll have a nice vacation, and everyone will see you again next week for another edition of Fire Law Roundup.